We're going to go ahead and get started. Hi, I'm Shannon Guthrie. I am the chair of the Dallas Bar Association Probate Trust and Estates section for the year 2020-2021. Welcome everyone to the first session of our summer probate or summer school, our probate summer school. And we've got a great presentation lined up for you, and I don't want to take much time before I just turn that over to our speakers. If you're joining us, you're here for the Probate Fundamentals Workshop, the Probate Summer School, session number 1. I do want to, a couple of announcements. If you need to enlarge the slides during the presentation, click on the view options and you should be able to play with that and determine how exactly you want to see the speakers or the slides on your screen. Also, we are going to have some Q&A. If you've got questions, send those into the Q&A icon. See that at the bottom of your screen, and you can put those in Q&A. Don't put those in the chat. We will be looking for those in the Q&A portion. There will also be some information provided in the chat, including the number for the CLE. For your full attendance today, you will get an hour and a half of credit. The number, if you want to grab a pen real quick, is 174-088-916. I'll repeat that again, and I'll give it again at the end of the presentation. That number is 174-088-916. Don't forget to enlarge your slides or change those under the view options on your screen, and also enter your questions into the Q&A portion under that icon so that we can look at those. Thank you everyone for attending. We've got 135 people on right now, so that's fantastic. I'm going to turn this over to our judge from Probate Court number 2, Judge Ingrid Warren, and she's going to be talking a little bit like by the pool, talking about the fundamentals workshop and notice, particularly notice and citations. So Judge Warren?
Thank you very much, Ms. Guthrie. We are going to start with our poolside chat with probate fundamentals, talking about notice and citation with respect to probate matters. And as you all know, our subject today is about administration. How do you actually obtain an administration? We have Matthew Rittmeyer, who's going to discuss. You saw him briefly for a moment. He's going to talk to you about what your applications need to say. And I'm going to start you off with a conversation about notice and citation. Notice and citation happens to be very detailed in probate, as we all know, and it can wind up being somewhat cumbersome. So we're going to talk about that. But in order to make this fun, since this is summer school, we each have a theme. Mine is poolside, and you'll see that Matthew Rittmeyer is going to talk about beaches, or his theme's going to be beaches, and then Mark Caldwell, his theme's going to be amusement parks. In order to make sure that we all continue to have fun during this presentation, we're going to do some digital door knockers or digital door prizes. So when I'm going to reach some point, I'll have a slide and I'll ask you a trivia question. And the first person that can respond in the Q&A section with the correct answer, we will send you a $15 gift card to Starbucks. So keep your eyes and ears open for that. Why don't we go ahead and begin now? All right, Probate Fundamentals Workshop. Citation and notice. Well, what's the difference between notice and citation? We talk about it interchangeably all the time in probate. Well, believe it or not, there really is a difference. Notice is about notification required to inform a person, and it's not a command. It could be a party or a personal representative. The clerk or the court can actually issue a notice. Citation, on the other hand, is a little different. It's a court-issued writ that commands the respondent to appear at a certain time and place in order to take an action, and their failure to do so can result in certain consequences. Another important thing to point out about citation is that citation must be issued by the clerk. Next, we're going to cover citation with respect to wills. So we're going to focus exclusively on wills at this time. Citation for probate of wills. Now, we all know this. This actually is the default that most people think about when you think about citation for wills. That's section 258.001. And in order to make sure that we follow the technical points in the code, I've actually put the sections on the code in my slide presentation so that we can go over those. It says that it shall be served by posting. That's the portion that I've highlighted under B. And it lists what the application and what the citation must say. This must be issued by the clerk, as you can see in A. The clerk shall issue the citation. The citation will have the details about the application, the nature of the application, the testator's name, and the applicant's name. And it's important to point out with respect to this slide that you really focus on making sure the testator's name is correct and the applicant's name is correct. Citations on applications for probate of wills not produced in court. Now, this is where we start to get into a little bit of a complication, but I want you to notice a distinction here. It says that the clerk shall issue citation, but look at who the citation is going to this time. It's going to the parties interested in the estate. Now, who are those people? It says it shall be served in B to the testator's heirs by personal service if the heirs are residents of the state of Texas. And if not, it can be served by publication if the heirs are not residents. Then it also says that let's see if we can move this here so that we can see this a little bit better. I don't think there's any convenient place to move it. Let's see. Well, we'll just move it up so that we can see the remainder of that section. Service of the citation is required by A, publication if the heirs are not residents of the state of Texas and our name and our addresses are unknown, or the heirs are actually transient persons. Now here, the court is prohibited from acting in the event that the citation is not returned. Just wanted to point that out. We all intuitively know it, but oftentimes courts are asked to go ahead and have a hearing in the event that the citation is not returned. This is just to highlight the point that we cannot sign the order because technically we shouldn't have had the hearing, which is why we have to wait to see whether or not there's an objection to the citation. Now moving on to notices with respect to applications for the probate of wills that are more than 4 years after the date of death. Notice to heirs is covered by 258.051. The appointment of attorney ad litem is 258.052, and previously admitted wills is 258.053. Notice to heirs. Now, with respect to a will that's being offered more than 4 years after the date of death, Section 258.051 covers what that notice must look like. What you want to pay attention to here is that the notice must contain the statement in B. And so B says the statement must say that the testator's property will pass to the heirs if the will is not offered for probate. And B1B talks about the person who's offering the will may not be in default. Now Matthew Rittmeyer is going to tell you more about what the law when it comes to default and how to hopefully avoid that in your situation. With respect to C, you're not required, the code makes it very clear, you're not required to have notice and you're not required to issue the notice if you actually get a waiver, but the waiver must contain the language that's in B. If you're not able to locate the identity of all the heirs, then the court can appoint an attorney ad litem whose job it is to protect the interests of the unknown heirs, or the people that you were not able to locate. Previously admitted wills. This section, this doesn't come up very often, but in the event that it actually does, I wanted to be sure to include that in this particular slide. The period for admitting the will to probate, that is, it's hard to see it here. That's, oh, there we go, 256.003. So here we're talking about the previously admitted will, where requires notice to the beneficiaries of the testator's probated will instead of the heirs at law. So that's the main distinction with respect to a will that's already been admitted and you're having to issue notice to the persons named in the prior will. Service.
Judge, Judge Warren, I don't see that your slides are advancing. I don't know if that's happening to others, but so maybe people can let us know if the slides aren't advancing.
Which slide are you seeing now? On my screen, I'm showing service by publication or other substituted service.
We're still on the first slide, I believe. We're still at 258.002 on citation. And it appears it's not just my screen.
I see, okay.
May have to pull out of the screen share and go back in.
All right, let me see something here. Let's see, 1 second. One moment here. Think about all the things that we could be doing right now if it wasn't for COVID-19. And so, you know, one of those things when I came up with this idea of, all right, we're going to start over. One moment.
And if a couple of people will let us know if they advance so we get some response. It doesn't have to be everybody, but maybe a few people.
Okay, sure. Let's see.
Yeah, if you go to your chat, everyone, the PowerPoint, there's a link to the slides, so you can actually pull those up under the chat feature. The icon should be at the bottom of your screen next to the Q&A icon. So if you'll pull that up, you can actually click on that link, and we can, if we aren't able to advance them, then people can look at them on their computer.
Okay, let's try it once more. Are they advancing now?
Yes, they are.
Okay, great. I'm moving to the slide where I stopped talking. Okay, previously admitted wills. Here we are. Service by publication or other substituted service. Can you all see that?
Yes.
Thank you. Service by publication. So this section deals with, this is also in the suite of, I call it the suite of notice provisions for applications to admit wills to probate. So this suite deals with publication for people who you can't identify or you can't find. And this is when you're dealing with a copy of a will or a will that's been offered more than 4 years after the date of death. I want to point, the reason I brought this slide up is because I want to point out the reference to Rule 109 of the Texas Rules of Civil Procedure. And we didn't want to bore you with all the details to what Rule 109 says, but what you should know, that's the section that deals with service by publication as substitute service for individuals that you can't find. And make a note that that section also allows the court to appoint an attorney ad litem as well for people that are served by publication under Rule 109. Well, here we are to our first trivia question. The first person that can guess the nation that this flag belongs to will get a gift card. So this flag represents the island that grows 42 acres each year. It also represents the only island that grows coffee commercially. What country is this? It's also a country that I would love to visit this year in the event that it's safe to travel. Well, I know it's safe to travel, but in the event I feel comfortable traveling. Now let's talk about, you all can see that now, determination of airships. So here are the code sections that deal with determination of airships. And I say that with a caveat, and I'm going to cover the caveat a little bit later. This code, the sections here under Chapter 202 are specifically designed to deal with notice for proceedings to declare heirs. This is actually in the suite of cases or the subchapter, that the suite of statutes or the subchapter statutes that talk about heirship applications. The reason I'm making that distinction is because at a later point, I'm going to reference you to a general provision about notice that is not referenced anywhere else in the code. So in the heirship section under 202.051, that's your section that deals with service of citation by mail, when you actually know the person's name and their address is known. The section 202.052 deals with service of citation by publication. 202.053 required posting of certain citations. 202.054 personal service of citation. 202.055 service of citation of certain persons, and 202.056 waiver of citation and affidavit of waiver. Service of citation by mail, when you actually know the person's name and their address. What I want to point out here is that the distinction that the code makes is whether or not the person is 12 years of age, or they're older, or they're younger than 12 years of age. Here it says that each distributee who's under 12, who's 12 or older, is required to receive notice. Now, if the person is younger than 12, then their parent, the managing conservator, or the guardian of the distributee can actually receive the notice instead of the individual. Citation by publication. If the address of the person or the entity where citation is required cannot be ascertained, then you can actually serve that person by publication in the county where the proceeding is actually pending, and in the county of the last residence of the decedent, who is also, well, the decedent for that particular matter. Posting, required posting of citation, except in a proceeding in which citation is served by publication, which is what we just went over. It may be posted when the proceeding is commenced, in the county in which the proceeding is commenced, and also in the county of the last residence of the decedent, who is also the subject of the proceeding. So that's when, well, if you don't have the, let me go back to the prior slide. Let's see. So here's citation by publication. This talks about when you know the person's address or the entity, person or the entity of whose citation is required to be served. If it cannot be ascertained, then they must be served by publication. I want to make sure I point out the distinction here. Required posting of certain citations. Now, if we're not dealing with a section that we just referenced, then the heirship must be posted in the county where it's currently proceeding, and also in the county of the last residence of the decedent, in the event that they're different. Personal service. Now, the court can always require personal service of anyone that's named, and sometimes you actually may want to issue personal service as opposed to the certified mail service, which we went over by mail earlier. I'm going to explain what I mean by personal citation soon, but just bookmark that and know that it's coming. Now, the party who's actually filing the application, you don't need to serve them, of course. Just wanted to point that slide out to you. Waiver of citation. The code specifically says that you can have a waiver, but there are certain exceptions to the waiver. That the exceptions depend on whether or not the person is 12 years of age or older, back to that, or the person is younger than 12. If they are younger than 12, then they may waive, but the person that can waive, or the people that can waive for the person younger than 12, is listed in B, a parent, a managing conservator, a guardian, an attorney ad litem, or a guardian ad litem. If they are over 12 years of age, they may not waive. So that means that the parent, the managing conservator, the guardian, the attorney ad litem, or the guardian ad litem cannot waive for the minor, and the minor themselves cannot waive. This affidavit of service of citation, this slide is really meant to show you the highlighted portion here, B. This is what I consider to be, let me move this so you can see it. Let's see, 1 second. All right. Now this in my opinion is a section that was written for judges because it shows us your work. This reminds me of geometry in the 10th grade, which is when I took geometry, where you're always told to show your work, or any math class where you have to show your work. This is the section that says, show your work to the court. Show us where you've issued citation correctly and actually support it with certificates. This is a very important section because actually the code says that you can't move forward without it. And it also helps the court substantially. We're at another guess the flag. Now this flag represents, let's see, hold on a minute, let me move this so you can see it. This flag has been made famous, or actually it's been made famous by a movie. And in the movie, there's a song that says, "I like to move it, by King Julian." Do you know the name of this country? Next, we're going to talk about citations and notice in general on opening and administration. So now we're moving away from an application to admit a will to probate. Now we're just going to talk about administrations. Let's see, this around here. Citation on application for issuance of letters of administration, Chapter 303 or Section 303.001 of the Estates Code. This looks very similar to our section about posted notice for wills. You'll notice it's the same information. It has the name of the application, the nature of the application, the decedent's name, and the applicant's name. Now, this is issued by the clerk, and it's actually posted. You'll see where my cursor is under B. Once more, actions are prohibited by the court until citation has been returned. We have another guess the flag. Let's see, hold on a minute. You can't guess it if you can't see it. Here we go, guess the flag. This flag represents the island that's infamous for shipwrecks and missing planes. The island's name likely appears alongside a three-sided figure. Do you know what country this is? Do you know what country this is? Also a trivia fact, I found out that Mark Caldwell lived in this country, or maybe was actually born. Sorry, this is not a country, this is a state. I'm going to say that. This is a state. So he was born in this particular, actually, if I have this correct, yes, he was born in this particular state. Well, if I have it wrong, just let me know, but we will see. We do have the answers to all these. Procedural matters. Okay, now this is the part when I said I was going to get to this, I was going to show you the section that deals in general with citations. So earlier we covered sections that tell you what has to occur with respect to the application that you file. For instance, wills, general wills with no problems, no issues with respect to whether or not it's a lost will or whether or not it's being offered more than 4 years after the date of death. And then also we talked about airships, and we talked about the specific provisions related to airships within the subchapter covering airships. Now we're actually going to go to the general provisions in Chapter 51 of the Texas Estates Code. Here we talk about, we're going to discuss what does it mean when the code says that you must have personal service. What does it mean when it says service by mail and service by posting and service by publication? Personal service. Now here's what the code means when it comes to personal service. I want to point out here that this can be very confusing, and here's why. So I want you to read this closely with me. Except as otherwise provided by subsection B, if personal service of citation or notice is required, it says the citation or notice must be served on the attorney of record for the person to be cited. And then it also says that under B, that if the person to be cited does not have an attorney, then it says that the sheriff or constable can also issue the citation or notice. The reason I'm pointing this out, because even though the code says citation and notice, it depends on which code section you are using to support your personal service. So if you are referencing one of the earlier code section that talks about notice, or a section that we've not discussed today that deals with notice, then you will deal with the notice provisions, and those are by the personal representative. Or the citation will have to be issued by the clerk, depending on which section you are using to support this section 51.051. Let's cover B again. So if the person to be cited or notified does not have an attorney, which is generally the case when you're initiating a matter, or if they do, you may not know them at that time. It says the sheriff or constable shall serve the citation or notice by delivering a copy of the citation or notice to the person to be cited or notified in person, if the person to whom the citation or notice the citation or notice is directed is in this state, or any disinterested person competent to make an oath that the citation or notice were served may serve the citation or notice if the person lives outside of the state or if they're absent from the state. The return on this is at least 10 days. If the citation or notice is attempted, now this is really important, I want you all to focus on this, on D. Now, if the code requires personal service and the citation is attempted but is unsuccessful, and the person can't be found for whatever reason it's unsuccessful, the code says right here on the next to last line, service of the new citation must be made by publication. So this section gives you an alternative in the event that your personal service is insufficient or it's not effective. Same thing with the service by mail. So here it says that, and I want you to pay particular attention to this too, because this matters with respect to airships. It comes up a lot in airship applications where notice isn't proper because the personal representative, or in this case, the proposed personal representative, is asking the court, has personally, or is attempted to personally serve by mail the application for airship. But that's not what the code requires. The code actually requires the county clerk to serve by citation the citation for the application to admit the will to probate, along with a copy of the application. And it says that in some instances she can do it by regular mail, and then also under B, now here's where it says the county clerk shall issue citation and it shall be served by registered or certified mail. Now, you may recall earlier in chapter 202 when we were talking about airship applications, it said that the personal service had to be by registered or certified mail. And here is where we find out that the clerk is the one who's responsible for actually mailing that to the distributees or to the prospective heirs at law. Under D, it says that the county clerk or personal representative shall mail a citation or notice under subsection B, which is what we just covered. With the instruction, it lists the information that must be included in the citation. The return on this is slightly different. It's actually 20 days as opposed to the ordinary 10 days, which is what we're accustomed to sometimes in probate. I want you to pay attention to this too as well. I'm going to move this up so you can see it. A copy of the citation or notice that's described above, along with a certificate of the person serving the citation or notice, must be included, and it also shall be filed and recorded. A return receipt shall be attached. So that means that we have to have the green card. The clerk has to have the green card. It's not enough just to be able to find the green card online. The clerk has to have the green card because the clerk is the one who actually issued the citation. And then the clerk has to complete an affidavit saying that the green card was returned. Under G, Once more, the code gives you an out. What if the person did not personally sign the green card? Then service is not effective. So code says, well, if citation is undelivered, then we can issue a new citation. Clerk has to issue the new citation, and this time it's posted. While we're here on the subject of posting, I just want to point out to those that don't know, all postings are located in George Allen Courthouse. As soon as you walk into the courthouse to the very left, you will see a wall where all the postings are for all the probate matters. So if you're ever curious and you want to know whether or not a posting is there, once the posting is issued by the clerk, you can go there and see it along with other postings. Or you can just wait till it's returned and you'll see it in the file as well. Service by posting. All right, so here the clerk also issues the original citation. The sheriff or constable is actually one who goes over there and posts it. It's not on the door of our county courthouse. In fact, it's actually on I just told you where it is. It's inside of the courthouse to the left as soon as you enter. This is the 10-day return date here. And then the clerk actually returns it. That's what the C and D deal with. Here's a sample return of service. So I want to point out a couple of things here with this slide. You'll notice here at the very top, it talks about the application. Why am I pointing this out? If you are double checking your citation, you want to make sure that it's correct. You want to make sure it identifies your application correctly. Here we have the estate of blank. You want to make sure that the name of the decedent is spelled correctly. That appears in this spot where my arrow is, and then also here. And here is the name of the person who's offering the will for probate in this instance. And also here's once more where we will see the decedent's name. And then you'll see here that this person wants letters issued. This tells the person how much time they have to respond and when to file their answer. You'll see it's the first Monday after this is returned, and this is the return date, Monday, February the 24th. I believe that was of this year. At the bottom, let's go back, sorry about that. At the bottom here is where we have the return of service by the constable, which tells the court that we can go ahead and hear this matter. Service by publication. We're all familiar with that. I won't spend a lot of time here. This is where in Dallas County, we use daily commercial record in order to issue the service by publication. Return and proof of service. We talked a little bit about this. Let me go in a little more detail here. Requirements for return on citation and notice served by personal service under 51.101. So the return must be endorsed and attached to the citation, certifying that, state the date and the place of the service, certify that a copy of the citation or notice was delivered to the person as directed, and subscribed and sworn by the authorized person, and returned to the county clerk. Validity of service and return on citation of notices served by posting. We've covered that. There's not any additional information to be gained by going over that slide, but I just wanted to point it out and show you where it's located in the code. Proof of service. Proof of service 51.103. Now, it must be filed before the hearing, and it consists of, if the service is made by the sheriff or constable, the return of service. If it's made by a private process server, then the person's affidavit. If this service is made by mail, again, I want to point this out. This reiterates the point about airships or any type of service by mail. The certificate of the county clerk making the service, the citation notice was mailed and the date of the mailing, and the return receipt attached to a certificate of affidavit, to their certificate or the affidavit. And also, I want to point this out too. You may have heard a little bit about the new rule of service on the internet, which became effective as of September the 1st of last year of 2019. Here, if I've not seen this used yet, but I wanted to point it out in the event that it ever occurs, that this service must be made by publication, and we have to have an affidavit saying that the service was perfected. But this affidavit has to be issued by the Office of Court Administration of the Texas judicial system or an employee of that office. And there are some other requirements here as well. But then it also tells you that the affidavit must include, we also have to have an affidavit made by the publisher of the newspaper where a notice was published. So it says, and you must have those two requirements. Personal service, we've gone over this. It just talks about the time for perfection and that it must be issued and returned to the clerk. Alternative procedures for issuance of service and return. You can file an application for alternative service under this section 51.151. This is the Estates Code version of the Rules of Civil Procedure, and it tracks pretty closely that rule. Additional notice provisions, waiver of notice of the hearing, and request for notice of filing of pleadings and service of notice of intention to take depositions. So waiver of notice of a hearing. We saw waivers earlier when we were dealing with heirship applications, but here the code talks once more again about waivers. And we also saw waivers when we were talking about 258 under, I can't remember the specific code section, but it was saying how if you have a will that's being offered more than 4 years after the date of death, you can actually, it says what the waiver must include. Here's a general provision that impacts all waivers in the Estates Code. So it just says it has to be a legal competent person. If you're talking about a trustee, then the trustee of a trust may waive notice on behalf of the beneficiary of a trust. A counsel or other representative of a foreign government can also enter an appearance and waive notice under subsection A on behalf of the person that's services required. And then also, as we all know, if you show up in court and you didn't get a formal notice of the hearing, you have waived notice and you are subject to the court's jurisdiction. Depending on, assuming it's an in rem matter, not a, or an in-person matter, not an in rem matter before the court. Requests, so I had to go back a slide. So I'm now on request of notice of filing. This is an interesting provision. Not many people know about this. I wanted to point it out. This is a notice, so it's not issued by the clerk, but what it says is if you want to know what's happening in an administration of an estate and you'd like to know what pleadings are are filed, then you have to ask for that notice. You may have participated in a contest. You may have been involved in preliminary matters in order to acquire the letters or get the will admitted to probate or have someone appointed as an administrator, but that doesn't necessarily entitle you to all the pleadings related to the administration. Here is a code section that says that the clerk has to provide notice to you if for everything related to the administration. But notice in B, if the clerk does not comply with the section, it does not mean that the proceeding is invalid. So you'd also want to check Odyssey or check online to make sure that you are actually getting all of your notices of filings in the case. Service of notice of intention to take deposition by written questions. I'm not going to spend a lot of time here. I just wanted to point it out and let you know where it is. The reason I'm not is because I believe that Zoom, the very resource that we're using to conduct today's webinar, is an alternative and therefore makes deposition by written questions not needed as much. Frequently asked questions. I'm just going to cover a few of these near the end of my presentation, and I just wanted to cover them just to kind of reiterate and summarize some of the things we've talked about. Do I need to request notice of citation issued by the clerk? Yes, by completing the due process form. Can a minor sign a waiver in an heirship proceeding if the minor is over 12? Let's see. No, incompetents are not permitted to sign waivers, and then I give you the code section. Let's drop down to the last one. Can I request personal service for an heirship instead of service by certified mail? Yes, you may, and the code actually allows it as well. You can request it as an alternative service, or you can just go ahead and, actually you can do it on your own. I don't see anything wrong with that. Common mistake. Let's switch gears now and talk briefly about heirships in the time that I have remaining. So common mistakes found in heirship applications. Here for, with respect to number one, material facts are omitted about the person's marital and family history. Here's an example. If the applicant says, or the application says that the grandchildren inherit from the decedent, but it doesn't explain to me why we're talking about grandchildren, meaning which parent predeceased or post-deceased the decedent. So we need to know that. How are you reaching your conclusion that the grandchildren are entitled to inherit? Applications and proposed judgments only classify the decedent's property, and they only classify some of the decedent's property. So let me explain what that means. A lot of times I'll get a proposed judgment that only wants me to deal with the community property of the estate. It doesn't deal with separate property. And then I'll hear, well, the decedent and their surviving spouse were married for more than 50 years. And I'll say, well, Judge, there is no community property. I'm sorry, there is no separate property. There's only community property. So we don't have to include separate property in the order or the judgment determining the heirs of the estate. Well, that's not totally correct, because we want to make sure that in our judgment that we deal with all aspects of the decedent's possible property. So we want to make sure we deal with personal property, personal separate property, and we also want to make sure we deal with separate real property, whether we know it exists or not, because if we don't, then we create an issue where at a later date, that judgment may be insufficient to deal with some after acquired property, or it may make it difficult for someone to inherit through the decedent, where they're relying on that judgment of heirship, because it does not tell you who takes certain property. So therefore, all of our judgments of heirship cover any property that the decedent could have owned at the time of death, whether or not the decedent owned that property or not. For the court to do otherwise would require the court to have a declaratory judgment as to the type of property that the decedent owned at the time of death. And even then, it's not a good practice, because as I stated before, the order does not cover everything the decedent could have possibly owned. Paternal inheritance, that's another big issue. So you want to make sure under 201.052 and also the Texas Family Code, Chapter 160, that you include the paternal inheritance and why it is that this person is able to take from the male decedent. This is another big common mistake that I see in heirship applications under number 5. Interpreting the Estates Code, section 201.003 incorrectly. So here's what it says. One half of the community estate is retained by the surviving spouse, and the other one half passes to the decedent's spouse's children or descendants. A lot of times people read that to say that the surviving spouse inherits from the decedent's portion of the community property, when in fact they don't. They retain what they actually own, and then the other children, or the children from any other marriage for that matter, take the decedent's portion of the community property. The surviving spouse's portion of the community property should not show up on the judgment of heirship for the decedent. Also, failure to establish informal common law marriage. All right, I'm nearing the end here. Texas descent and distribution. This is on our website. I just wanted to include this. This just helps with the basics of figuring out who takes what and when and from whom. It talks about post-death and also post-deceased, as well as people who pre-deceased the decedent and how they take. Well, that's it for my presentation. I invite you all to use these sections and use them to your benefit.
Judge Warren, thank you so much. Would you mind fielding just a couple of quick questions?
Let's see. I can.
Okay. First of all, we have a question, and this is probably pretty easy to answer, but what does notice actually mean? Is that an email, a piece of paper? Can you deliver it by mail? I believe that's covered in your paper, and if you'd like to just, defer to that, then we can.
Sure. Notice is, I want to make sure I leave time for the other presenters. So
sure.
I want to highlight one thing though. it depends on what portion of the code you're relying on. So if you're talking about 308, 308 notice that the will's been admitted, the code's very specific on what that notice must look like. If you're talking about the notice on an application for an annual accounting or a final accounting, the code is specific on what that type of notice looks like. So you have to actually look at the section that's requiring the notice to know what it must look like and how you have to issue it.
And someone asked a question about, how do we serve a minor again? I think we'll just defer back to look at the code. It's in your slides. The last one is, what are examples, if you can provide some, of under the 51051B2 when you're trying to give personal notice and they don't have an attorney? So if you have a person who a disinterested person competent to make an oath can actually, give that notice. And so have you ever, had to do that, and what might be an example of that? I know they have to be out of state.
Right. I've not actually seen a provision used, or at least I can't think of a situation where that was actually used, where you have, the way I read that section, it's instead of saying that I really want to go back to my slide, but no, everything is digital here and I don't want to waste time trying to find that
Well,
slide.
if you'd rather answer that later, we could do that too.
Oh, that's fine too. If that person would like to reach out to the office, I can certainly answer that question directly, and I can.
Right. It may be a little specific for purposes of this. So, and that's the last question we have. So at this point, I think that was great. Certainly good for everybody in the notice and citation area and distinguishing those. Our next speaker is Matthew Rip Mayer. Everyone, I think, calls him Rip Meyer, but we found out today, because I asked, that it's actually Rip Mayer, like John Mayer, kind of, but he's not the same. Do you sing? You might sing. I don't know. I have to wait and see that. Matthew is with the Blum firm in Dallas. He recently made a change, and he's going to talk to us about getting your letters. Matthew.
Thank you, Shannon. I want to also first tease ahead that Mark Caldwell will be speaking after me regarding attorney ad litems. I want to apologize to Mark in advance. I am in a suit. I was supposed to be wearing a Hawaiian shirt, but as you can see, I'm at the beach, and due to an unfortunate windsurfing incident yesterday, I lost my Hawaiian shirt, and so that's why I am in a suit today. Also, I want to thank Judge Warren for putting together this workshop. This is the first of 3. I encourage all the attendees to look for emails promoting the next workshop. We understand that this workshop's a little dry, but really what I'm going to be covering is critical to administering an estate. If you don't admit a will or probate, if you don't get your letters, it's really difficult to do anything else. The topics I'm going to be covering today are the lost copy of a will offered for probate more than 4 years after death, and creating an independent administration. These are all a little bit trickier situations, and so that's why we're going to cover them today. So let's go ahead and get started. So you have a meeting with a client, and the client looks a little stressed out. They're stressed out because they cannot find the original will. And you, as the attorney, try to assure them that no original will, no problem. Of course, with the caveat, the presumption when an original will cannot be produced is that the will was revoked by the testator through a physical act. Now, how do we know that? There's case law that tells us this, and I'll point out that I pulled this case from Professor Byers' annotated Texas Estates Code. At the end of my slides, I have resources links, and you will see there's a link to download his annotated Estates Code. If you don't already have it saved on your desktop and always open on your computer, I recommend you do that. I always have it open, and I can Control F and find anything I'm looking for at any moment. This case in particular, Mingo v. Mingo, lets us know that when the testator had access to the will, and then there's a failure to produce the original will, there's a presumption that the testator revoked the will. And we also know under Chapter 253.002 that physical revocation of a will is permitted. A testator can do so by destroying it themselves or directing someone to destroy it in their presence. So you let the client know all of these things. The client's going to be a little bummed out. They're not going to like hearing that there's a presumption it's revoked, but you're going to tell them, it's okay. I remember something. I recently attended an amazing probate workshop, and I learned a few things about probating a copy of a will. Number one, as held in the estate of Catlin, the court explained that an original will proponent a proponent of a will, a copy of a will, does not have to demonstrate an affirmative reason why the original will cannot be located, such as the eating habits of the neighbor's goat, the occurrence of a Kansas tornado, or the devastation of a flash flood, or the like. And as Professor Beyer points out in his version of the Estates Code, the Catlin opinion and others have almost made revocation by a physical act impossible. The situation is that if there is no contest, if all the beneficiaries agree that the copy of the will is in fact sufficient and that the reason the original cannot be produced was not because of revocation, it will be most likely admitted to probate. So the takeaway here is, if your client wants to revoke his or her current will and you do estate planning, you need to execute a new will, or at the very least a written revocation. Now you'll notice under section 253.002, a written revocation has the same formality requirements as a new will, so you might as well go ahead and write that new will. So now that we know that although there's a presumption, it's not too terribly difficult to overcome, assuming all the beneficiaries are getting along and there's no contest, then what do you do to probate a copy of the will? And the theme here is going to be, remember that the code is your friend. So what code sections apply here? First, we're going to look at chapter 256.054, which talks about additional application requirements when no will is produced. Next, we're going to look at proof of a will not produced in court under 256.156. There's also chapter 257.053, which you'll notice is identical to 256.054. The only difference there being chapter 257 addresses muniment of title. And then, as Judge Warren already covered, there are different citation requirements when you are probating a copy of a will. And real quick, anytime you are going to probate a will, whether it's a copy or an original, or you're seeking letters or muniment of title, you always want to start with these chapters I've highlighted here. As you can see from their titles, they address all the issues that you would need to look at when you're probating a will. So first, in addition to those general requirements that are held under 256.052 for any application looking to admit a will to probate, you also have to look to 256.054 and add these additional facts to your application. One, the reason why the will cannot be produced. Two, the contents of the will as far as known, which of course the contents are going to be easy to prove because you have a copy and folks are going to be saying that that is in fact a copy of the original. You're going to have to list the name and address of each beneficiary under the will and each heir who would take under intestacy. And in addition, you need to identify whether each of those individuals is an adult or a minor, what their relationship was to the testator, and list their address. As you can see, 257.053 is identical to the previous provision we just covered. This is just if you're looking for a muniment of title rather than full-on letters. Additionally, you will have to submit the following proof. As you see under section A here in chapter 256.156, when a will cannot be produced in court, it must be proved in the same manner as provided in section 256.153 for an attested will. What that means is, although you have a copy of a will that has a self-proving affidavit, it will not suffice and meet the requirements of the evidence needed under 256.153. That's the whole purpose of a self-proving affidavit. It provides that testimony for you. In these situations where you do not have the original, Chapter 256.156 tells us you have to also put on that additional evidence under 256.153, which most of the times we do not do with self-proved wills. Additionally, you are going to have to state the cause of the non-production of the will. And as we've said earlier, this is not a terrible burden. As long as all the beneficiaries are in agreement, that should be pretty easy to overcome. Additionally, you have to produce the contents of the will, which are often shown in the copy. As Judge Warren mentioned earlier, we have different citation requirements when there's no original produced. The important things to remember here is that all of the heirs have to be served by personal service if they're residents of the state and their address is known. If you do not know all of the heirs or their addresses, then you have to serve by publication. But if you've already got everyone in agreement that this copy is in fact a copy of the original, most likely they're getting along well enough to also agree to a waiver of service of citation. And I recommend that you obtain those rather than going through the expense of personal service. I learned yesterday on our call, Mark had some good advice that when you're sending that cover letter or cover email with the waiver of service of citation to all the heirs, include the language in the code regarding the requirement to produce the original will if they are in fact in possession of it, and deposit it with the clerk of the probate court. That way you can also show these letters to the court when you're at your prove-up hearing to demonstrate even further all the efforts you took to locate the original. So we've gone through all of that. We've read through the code. We provided the additional proof. We got waivers, or we personally served the heirs, or we published notice. We had a hearing. We put on the additional proof demonstrating why the original will cannot be found, but it wasn't revoked, and the contents of the will. We're exhausted, but now let's celebrate for a moment. We got through it. We got the will admitted to probate. But as you know, our work never ends, and you're meeting with your next client, and good news, the client has the original will. And then you start to get information from the client and learn the testator died more than 4 years ago. And so you have to let that client know that there are many provisions in the code that talk about filing an application for probate of will must be done prior to the 4th anniversary from the testator's date of death. And here are some of the code sections. You'll notice there is some exceptions here under 301.002, but again, it mentions that you have to file the application prior to the 4th anniversary. Another code section. So you let the client know there are some issues here. You were supposed to do this prior to the 4th year. Your client's going to be like George Costanza here, not going to be happy. But if your client is like Bart Simpson, I'm sorry, wrong slide. But you're going to tell your client, I attended a recent probate workshop and I know a few things about getting over this 4-year requirement. And your client's going to be like Lloyd here and tell you, oh, you're telling me there's a chance. And then you tell your client, if you're like Bart Simpson and you swear it wasn't your fault, then you can get the will admitted to probate under, well, first remember our friends, the estates code. Here are the relevant sections we'll be looking at. And in particular, chapter 256.003, the period for admitting a will to probate. As you can see here, if your client is like Bart Simpson and it's not their fault, then under chapter 256.003, a will can be admitted to probate if the applicant can prove that the applicant was not in default in failing to present the will for probate on or before the 4th anniversary of the testator's death. And there's good news here. The courts have been lenient in assessing whether or not the applicant is in default. All of the annotated codes out there have references to different cases. Professor Byers references case where the applicant stated that she was not educated and economically challenged, and the court accepted that as a reason that she was not in default. Also, very importantly, just last year, the Texas Supreme Court held in the Butler case that the court may only consider the applicant's default in determining whether to probate a will after 4 years. So it does not matter whether someone else, even the person through whom the applicant is claiming was in default, default is not attributable. It's only going to be looked at whether or not your applicant was in default. Now, typically, you are going to seek to admit a will for probate after 4 years as a muniment of title. But if you needed letters under Chapter 301.002B1, the court is permitted to issue letters of administration if it is necessary to receive or recover property due to an decedent's estate. Subsection B2, I don't think most of us are going to come into using much. As Judge Warren mentioned before, wills that are offered for probate more than 4 years after the date of death require the applicant give notice by service of process to each of the testator's heirs and be given before the probate of the testator's will. I am always a fan of waivers of notice and consent, and specifically Chapter 258.051C provides exact direction on what is needed under the waiver of notice and consent when you are seeking to probate a will after 4 years from the date of the testator's death. If the applicant cannot, with reasonable diligence, locate the address of any of the testator's heirs, or if any of the testator's heirs are unknown, the court will have to appoint an attorney ad litem, which Mark will talk about in a moment, to protect the interest of the testator's unknown heirs. Some additional, so now you've gotten the will admitted to probate all these years later. You overcome the requirement to probate the will within 4 years, and so it's time to celebrate. But you try to have a good old-fashioned high five with your buddy, and it doesn't quite go so well. And as we all know, there's a few other times where things don't go so well, and one of them is when a individual decides to write their own will, or as I like to call them, do-it-yourselfers. So in these situations, the testator decided to save a few bucks and make his own will with the help of the internet, probably. And lucky beneficiaries, they're going to inherit more money now, right? Just like these folks who decided to make their own cupcakes for a party. You saved a few bucks, and it's just as good as the store-bought ones, right? So in these situations, you are most likely going to have to create an independent administration. So when the do-it-yourself will left out the keyword independent, or when the will doesn't have the statutory language that most of us would include, saying that no other actions are required in the probate court other than the probating and recording of the will and the return of any required inventory, or if all the named executors are dead, disqualified, or not willing to serve, or there's no will at all. And often in these situations, there's so many mistakes or drafting errors or failing to write a will in the first place that can result in the need to create an independent administration. And often your client is Lloyd here on the moped, who is the named executor who decided to help mom or dad write the will. And Harry here is the other sibling and beneficiary getting upset at your client because they told him they should have gone to an attorney. And Lloyd says, but wait, I have a solution. I hired an attorney who recently attended a probate workshop that was amazing. And I know about creating an independent administration now. So if the beneficiaries all get along, or at least enough to understand the benefits of an independent administration over a dependent administration, for example, a time savings and money saving, well then you should look no further to your dear friend to figure out how to do this. Do you remember who your dear friend is? What's that? You weren't really paying attention? Well, I forgive you, and here you go. I'll remind you. There's your dear friend. There's your dear friend, the estates code. So really quickly, here are the sections that you will be looking at. It's subtitle I, independent administration. The creation of an independent administration is under chapter 401. Specifically, we're going to look at 401-002 and 03, and 401-004 for the means of establishing consent. Now, there's a lot of text here. Don't worry about reading it now. The main thing to remember is under 401-002A, this is a situation where testator wrote a will, but they forgot to include those keywords of independent or without further action. And in those situations, all the beneficiaries can get together and agree that the named executor should serve independently. They can do this either in the application itself or in separate consents. Under 401-002B, this is a situation where there's either no executor named in the will, or all the named executors are deceased or disqualified or just not willing to serve. In this situation, again, the beneficiaries under the will can all consent to an executor, and really they'll be serving as an independent administrator with what we call will annexed. Or in the intestate situation, where obviously there was no will, you're doing a judicial determination of heirship, and everybody, all the heirs can get together and agree on the administrator serving independently. Key thing there is, of course, you have to have the judicial determination first prior to the court appointing the independent administrator. You can do those in a joint application and have one hearing to accomplish this. Again, more text. The main thing here for 401-004 for means of establishing distributee consent is all distributees shall be served with citation and notice of the application unless they waive the issuance. And since you're already going to be getting folks to consent to the appointment of an independent administrator or executor, you might as well have them also sign a waiver of service of citation. Now, sometimes figuring out who the beneficiaries are and who the distributees are is confusing, especially if you have a pour-over will providing assets to the trust, or if the will is creating trust. If that's the situation, look at 401.004D, and it will tell you that the person or class of persons entitled to receive property outright from the trust on the decedent's death, and those first eligible to receive the income from the trust, are the required beneficiaries. Additionally, if there's a life estate created under the will, the life tenant or life tenants are considered the distributees, and they must be the ones that consent to the independent administration. Interestingly enough, the remainder men have no say here. I'm going to skip over these. 401.004 F and G. F talks about survival period. G talks about intestacy. I'm sorry, G talks about disclaimers. There's a presumption that none of the decedents are going to disclaim. And H here under 401.004 talks about if a beneficiary is deceased, the personal representative of his or her estate can consent. Few more considerations. If you are asking the court to create an independent administration, most likely the will does not contain a waiver of bond as well, or you're in an heirship situation and there's no waiver of bond. You should probably discuss with all of the heirs whether they want to waive that. If they do, you can ask the court to do so, and you can have the heirs or beneficiaries also add that to their waiver and consent. And also, you want to consider granting a power of sale. That is under 401.06 and can be included in the waiver and consent as well. And we are done. That's how I feel now. Maybe after I recharge for a second, I'll feel more like this. And you can look on the slides which Jack shared, and you can see resources and links to download those. And with that, I will turn it back to Shannon. Thank you.
Thank you very much, Matthew Mayer. Very interesting and lighthearted, and thank you for that. Very helpful. So we're going to move along and turn it over to Mark Caldwell. Am I frozen? No? Okay. For some reason, my screen froze. So Mark Caldwell, who is a shareholder at Caldwell, Bennett, Thomas, Torson, and Camp, and he is going to be talking to us about serving as an ad litem in an heirship determination. Mark.
Aloha, everybody. Welcome to Airship Land. It's amazing in 2020 that we're still talking about airships, as you think that a lot of people now would know to have a will when they die, but yet it seems to continue to happen. Folks out there do not have wills when they die, and so the law will write their will for them in an airship proceeding. And then, as Matthew was mentioning, even those that have wills sometimes decide to do it themselves with an internet will, and you have a partial intestacy problem. And so airships just remain relevant, and the number of ad litems that are going to be needed in these airships is going to continue to increase. So in an airship proceeding, what is an attorney ad litem's key role or key function? Well, it's really to verify or to test the allegations in the airship application. So is what they say true? Is that really the decedent's marital history and family history? That is really the core function, to make sure that if there were any folks who were left off the roller coaster here, they should have been included, and they should be invited to the proceeding. So not every case, you can go to the, not every case requires the same level of investigation. Some airship cases are simple, they're fairly routine. The family facts are not that complex. But then again, some cases really are. And so as an attorney ad litem, it's somewhere in between usually a rubber stamp and a extremely thorough turn over every kind of a stone investigation. Some of the complexities that you see in these cases include collateral heirs. Once it gets out to the collateral heirs, things can get fairly complex. Moieties are obviously very complex. You can have airships within airships. I'll talk about those a little bit more in a second. Those can add complexity to things. There can be adoption issues in your case. And then one of the ones that I think that we're seeing more and more now are decedents who were not domiciled in Texas when they died. And that can bring up some pretty interesting choice of law issues that we'll talk about in a second here. Next slide, Jack. Thanks. So remember, as I said, somehow it's between these two spectrums, the role of a rubber stamp or turn over every stone. In every airship, you have to represent the unknown heirs the same way, with the same vigor and the same astuteness that you would for a private client. And so there's a case here that I cited in re Estate of Stanton, where the attorney ad litem had standing and authority to oppose the appointment of a temporary administrator and apply for a third party. And I think in that case, the attorney ad litem thought the person wasn't qualified, and they said, hey, this could really impact some of these unknown heirs. If they're identified or they show up, they're going to want a competent, qualified, and not disqualified administrator. And that court affirmed the attorney ad litem standing in authority to make those arguments. And again, the attorney ad litem really has to exhaust all the remedies available to his client. So as Judge DeShazo used to say with guardianships, as an attorney ad litem, you're not supposed to roll over. You're supposed to make sure the T's are crossed and the I's are dotted, and things are as they should be. And so it's important to understand that you do have a very serious role, and you should take it seriously and do a competent investigation. Okay, next one, Jack. And so again, focus on the process in these airship investigations, not necessarily the result. You're not expected, nor will you find an unknown heir in every case. Not every case is going to be complex. Not every case is going to have um, rumors of unknown or unidentified heirs or potential heirs that were out there. Some cases are fairly straightforward, and people lived straightforward lives, and family facts are well known to everybody. And so what I try to do when I'm an attorney ad litem is I try to follow a very similar process every time, so that I know that my investigation follows a logical order. And that's really what I would tell everybody to do, is to really fine tune the process of your investigation and to focus on that, and the results will be what they be. And sometimes, airship applications are correct. Most of the time they are correct. And so you don't have to find somebody every time. So moving on to the next slide, what should you do as an attorney ad litem in an airship proceeding? Well, the top three things that I can think of are to be efficient. And to be efficient, you really need to have a plan, like I was mentioning, knowing your steps, knowing the investigation resources and tools that you're going to employ, knowing the law of intestacy, being able to identify where there would be the potential expansion of certain classes of heirs and what would cause the assumptions that are made in the airship application to be incorrect. And then finally, you need to be organized. And so if you can do all of those things, then I think that you can fulfill your role in a competent way and be paid a fair fee for your time, and to perform a solid service, not only for the court, but also for your colleagues. So efficiency and organization and planning, I think, are keys to succeeding as an attorney ad litem. And then obviously being educated on the substantive law of intestacy will help you know where you need to look. And then I think I would say just the last couple of things is, when you use your orders, I know Judge King mentions this in the intestacy manual, make sure that things are in fractions and not in percentages. That normally makes things a whole lot easier. So what should you not do as an attorney ad litem in an airship proceeding? Well, again, I think the risk on a lot of these cases is that rubber stamp mentality where people don't have a healthy sense of skepticism. And I say that, and it's not that everybody is lying when you interview them. A lot of times they just weren't asked the question the right way, or they weren't asked enough questions. And people's memories are imperfect. Another thing that can happen in these airship cases is that you can get to the disinterested witnesses, and the first thing right out of the gate that I always ask them is I ask them questions about their personal knowledge. What kind of personal knowledge did they have of these marital facts and family facts? And sometimes you'll find that this is just a witness because they couldn't find anybody else that they put forward, and they say, well, I'm generally familiar with it. I really didn't know the decedent for that long, or I've been told a lot of things third hand. And so having that kind of skepticism about the actual witness's competency can be helpful, because that evidence may not be as strong as it really should be for the applicant to carry their burden. Don't forget, or things to not do, I suppose, would be ignoring the possibility that there were embedded airships. And what I mean by an embedded airship is it's the difference between an heir who survived the decedent but are now deceased. In that case, that deceased heir's estate would actually be the heir in the judgment, versus heirs who predeceased died, so they died before the decedent, but they may have had other descendants. That's an embedded heirship. And then lastly, I know this is sort of one of those things that nobody should have to say, but being inconsiderate towards the applicant or the disinterested witnesses. Try to have some compassion. In all of these cases, probate is a difficult time for a lot of people. You'd be surprised how long it takes people to get over the grieving process. Talking about intimate family facts can be very difficult for people. So just be mindful of that and sort of have a good bedside manner, if you will, when you ask your questions. It goes a long way, and it certainly adds to a constructive, positive environment to address a lot of these airship questions. Moving on, so, how can I, as an attorney ad litem, be efficient? How can I have a plan and log and test to see, and how can I be organized? Well, one of the things that I did in preparing for this was I went ahead and disseminated sort of a skeletal outline of a chart or of an investigation checklist. And that's really the answer to this question on the next slide. Is you use a checklist or you have a worksheet. And so in the document that I believe will be made available to everybody, you'll see that you sort of start with understanding the basis for your appointment, and there's a section in the checklist on that. You identify who your clients are. Make sure that your clients were properly served with published notice. You file an answer in the case. Make a chart. I mean, I can't tell you how many times I go down for an airship hearing on a fairly complicated airship, and there's not a visual depiction of the facts. And it is so helpful when you're doing your cross-exam of witnesses to be able to use a demonstrative like that, both giving a copy to the court and giving a copy to the witness. It really, really helps people follow along and make sense of the relationships and how people fit together and how they're related to one another. So to the extent that you can make a chart and incorporate that into your checklist, it's very, very handy. It certainly goes a long way when you're interviewing witnesses on the telephone or during your cross-exam. And then think about the case and think about what facts would make the key airship allegations incorrect. So every airship application will have certain key airship allegations, and you want to try to think skeptically about those allegations and ask yourself what would make this allegation untrue. And then write those things out, and so you can incorporate those into your interviews. And then you want to track your findings and track your answers. And if you do it in a similar way as the way that I've suggested in this chart, you'll have both a handy sort of report ready to read and give to the court, but you'll also have your hearing preparation, your cross-exam already sort of ready to go. A couple of things on cross-exam. I always try to ask the witnesses about documents. Have they seen any documents that would cause them to believe that the allegations in the airship application were untrue? That's an important question to ask. Are there any documents out there that would cause them to believe things are not true? And then I always ask a catch-all question in my airships when I'm the attorney ad litem. Something like, is there anything else you think the court should know in determining who the decedent's heirs are? Give the witnesses a chance to sort of say things in the narrative. You'd be surprised what sometimes they add to the record, and sometimes it'll prompt further questions by the applicant's lawyer or by the judge. And don't forget about searching public records. You'll see in the chart that I've provided, there's a section there on looking at deeds, powers of attorney, documents like that to identify any other potential family relationships. Sometimes I'll also run like an accurate report or a public search report to check the identity of potential other family members. And then let's talk for a second, moving on, let's talk for a second now about airship cases and what to expect when it comes time for a fee. So most airship cases, like I mentioned, are fairly routine, and they're going to justify a routine and customary fee. And so one of the things that you can do to help yourself file a reasonable fee, like I said, is to be efficient and to be organized. And so that you won't spend a lot of unnecessary time chasing things down. So what should you do, though? Moving on to the next slide, what should you do as an ad litem if you have a significant amount of time in the case and you think that the case really did require significant investigation, or that it will require significant investigation? The first thing that I try to do is to communicate my findings to the applicant's counsel and say, hey, there's some there's some holes here in this family tree that I'm having a difficult time sort of shoring up. And so the witnesses or the documents that you've given me don't really answer these questions. And then discuss, identify and discuss what options there are to try to plug up those holes and what the anticipated time or cost will be with applicant's counsel, because to the extent that you can get something agreed to on the front end, that really makes a big difference when it comes time to file your application for attorney's fees, and you can present it as an agreed application because there wasn't any surprises or people knew what you were doing and why you were doing it. And then I think consider disclosing the status of your investigation to the court. In some cases, I have filed interim attorney ad litem reports, and I've asked the court to give me approval to utilize additional resources like private investigators or genealogists, things of that nature, because it's going to require a significant amount of time and work and energy, probably in the field, maybe that other folks are probably better suited to do at a lower hourly rate. And so you can bring those kinds of issues to the court. So what is reasonable compensation? Moving on to the next slide. Well, really what we're talking about here is we're talking about the Anderson factors, and that Garcia versus Martinez case is sort of the bellwether classic Texas Supreme Court case that says that, the same factors that are used to determine the reasonableness of attorney's fees in other cases are used to ascertain the reasonableness of an ad litem fee. Like in that case, it was a guardian ad litem. But you're talking about essentially the Anderson factors that are referenced there in that third bullet point. I won't go through all of those, but whenever you are testifying as to your attorney's fees, it's helpful to be able to be prepared to talk about those fees. Depending on the size of the airship and the kind of case it is, sometimes our firm will use a more lengthy, what I'd call kind of a litigation attorney's fees affidavit that you would see like an expert testify to in a contested case, and it goes into a lot more detail than sort of the probate manual sort of more, I'd say, short form affidavit. So sometimes attorney's fees do require a little bit more substantive work. So be familiar with those factors. And then of course you have the disciplinary rules, 104, and then it's always a must to check the local rules and check the guidelines. I know in Dallas County, the court has guidelines that govern the hourly rates that you can charge, and they also govern the processes or the process by which you apply for your fees, what documentation, what's required, and then the orders that are required. So it's always important to check those. And then moving on to the next slide, keep in mind that the court has significant discretion in awarding fees. It is measured under an abuse of discretion. It's a very difficult standard to overturn on appeal. Basically, the court has to act without reference to any guiding rules or principles, and the act has to be effectively arbitrary and unreasonable. So the court has a significant discretion when awarding attorney ad litem fees in an airship case. I would say, as an ad litem, have the right attitude when you serve as an attorney ad litem. Remember that you're fulfilling a really important role, not only to the court, the legal system at large, but also to your fellow colleagues. Chances are, you're going to be an ad litem on one of their cases. They're going to be an ad litem on one of your cases. Most airship cases are not your firm's leading revenue generator, and so you should treat them realistically when it comes to your fees. And that's what I try to do. And I think if you can do all of those things, then you can really fulfill your job as an attorney ad litem to the utmost and with great service. And so that's pretty much all I have. I know we're about out of time, so I would just say remember to have fun out there in airship land. Enjoy the process. So thank you very much.
Thank you, Mark. That's been great. I do have a question for you that came up on the Q&A. What procedural steps should someone take when an affidavit of airship, so not an airship determination, but an affidavit of airship, has been filed without notifying or listing all of the heirs. Do you have any thoughts on that?
Yeah, so if you find an affidavit of heirship, whether it's in your deed record search or whether it's brought to your attention some other way, and you find out that there are people that were on that affidavit of heirship that are not on the application, you do need to notify them of the proceeding. What I typically do is I will send a form letter to them, letting them know who I am, of my appointment, and give them a copy of the application. I tell them they need to enter an appearance or make a case. Their rights are at stake, and I'll bring that to the court's attention. But once they are identified or they are a potential known heir, then at that point they need to be before the court, and they need to their status needs to be confirmed or I guess disproven.
Great, thank you. One more question that just came up. In the case of an ad litem who has unknown heirs and a will that's being probated after 4 years, should an argument be made by that ad litem to nullify the will and to basically allow the heirs to inherit?
That's a really good question. So if you're an ad litem and you're representing the unknown heirs who would benefit by the will not being admitted to probate, then I think you have a duty to, again, cross the T's and dot the I's and hold the applicant to their burden of proof. I believe in your case to show that they're not in default. And so I do think that you have to test that. And those are hard cases, the not in default cases, because everybody looks at those a little bit differently. The answer really depends on who you ask. And just like probating a copy, case law seems pretty liberal. Probating a will after 4 years, it can seem flexible and liberal, but there are people that I think don't really meet the fact. And so as an ad litem, you got to have a healthy level of skepticism. And the harsher that result is on the heirs, I think the more care that analysis takes.
Great, thank you, Mark. Appreciate it. I know we've gone over a couple of minutes, but I do have just a couple of things really quickly to tell you. First of all, for those of you who don't already have it or know about it, the Dallas County Probate Practice Manual has been updated, and it has a ton of forms in it that are very helpful to you, procedural information. That's on the DBA website and under our section, and you can purchase that, or you are allowed to get it for free by volunteering for a case for DBAP. Go DBAP. Also, don't forget to go in and make sure you get your credit for your CLE today. The course number is in the chat section, which is a great segue for me to tell you that if you don't know this already, if you go down to the bottom of the chat section, there's those 3 little dots. You can actually save that chat and the information where we have the links to the slides if you need those, then that's there. Things that have been answered, questions that have been answered, so that you will have that information there. Also, the CLE number is in there. Don't forget about that. Also, Jack put in there, thank you, Jack, that next month when we have our summer school course, that's going to be on Wednesday, July 22nd at noon, so 12 p.m. And we're going to be talking about what happens after you get your letters testamentary or letters of administration. So don't forget about that. Thank you, everyone. I think we had a great day today, and we look forward to seeing everyone again. We had a great participation. Have a great day.